Hi, everyone. Harry here to talk about Donald Trump's petition for a stay before the Supreme Court to keep the mandate from returning to Judge Chutkan and keep his time in the DMZ, as it were, where nothing is advancing in the trial court, keep it going. All right. So on the one hand, in broad strokes, there's nothing particularly new or different. His second argument, which is truly a bozo argument, is this double jeopardy idea. It's not even based on the double jeopardy clause, but the idea is having been impeached and acquitted, it would violate double jeopardy principles in the impeachment judgment clause to indict him on criminal conduct. That's the second argument. The main one by far is an attempt to say that he must be immune because he really is going after the argument based on Marbury versus Madison and the distinction embedded there between discretionary acts and non-discretionary acts. And he wants to say this is discretionary and the judiciary can't interfere with it. Now, that's something he tried in the Court of Appeals. Judge Henderson showed some interest in it, and the D.C. Circuit really shot it down very much. In brief, he's just completely misconstruing the distinction. The discretionary acts that Chief Justice John Marshall was talking about in Marbury versus Madison are things that really are left completely to the president's discretion by law, like whom to nominate to the bench, for example, or whether to give a pardon. Not so smaller details like, can you break the criminal law? Can you violate U.S. laws at all? So that's where he staked his claim on, and the first one. He's also basically trying to say that the conduct, it's sort of a related argument, was something that fell within the outer perimeter of his official duties. Now, that matters in the immunity realm because the court has held before, not the D.C. Circuit, that the D.C. Circuit has applied it, but the notion there is in a civil context, you may not sue a president for acts done within her or his tenure that were within the official not just acts, but the outer perimeter of their official acts. So he wants to be saying the same regime should apply in the criminal law, and the D.C. Circuit really eviscerated that argument. But that's what he's saying. Okay, except, so on the first hand, nothing really new, but except he's made choices before the court. Now, I don't think those choices are necessarily his best ones, but it doesn't really matter. If the court takes the case, it can frame whatever questions it wants to consider. So his somewhat stumble-bum presentation of questions presented is kind of no moment. Now, the guts of the important part of his petition is marching through the factors for when and why you get a stay. That's what he's really needing. Because he filed in the Supreme Court today, the stay from the D.C. Circuit, the mandate doesn't issue, but now it's with the Supreme Court. So he wants to. There are certain factors for when you can do that. Basically, it's got to be very likely that the court's going to take up the question. And then in addition, likely you're going to win and you're being prejudiced if there's not a stay, the fairly stringent showing to make a higher court continue to keep a stay in place or to put a stay in place. And true to form, he's going all in on the delay aspect of it. He's asked them to grant a stay to also permit him to now go back to the Court of Appeals and do a rehearing en banc. The 6-day trigger that the panel provided didn't give him time to do both. We thought it was certain that he would have to go to the Supreme Court. Indeed, he did. But now he's saying, I want time to try my luck in the whole D.C. Circuit en banc. He wouldn't get it, but he'd get more time. And then he is also saying keep a stay until I give a proper petition for certiorari. That is where this is just saying, please impose a stay. 5 members of the Supreme Court, rule of 5 versus rule of 4 matters here. You've got to have 5 votes to impose a stay. Please impose a stay, and then in an undetermined time frame, he'll then do a petition for review under certiorari, and then we'll have the same languorous pace that he so hopes he can get. But I don't think it's going to happen here. So here's what I think is now going to happen. The Chief Justice happens to be the one who presides over the D.C. Circuit, so he'll submit this to everyone. And they will decide, I think, quite soon whether or not to grant the stay. Now, theoretically, they could decide to treat his stay motion as a petition for cert, just to kind of speed things up and accept it. Or they could just take it as a stay and not grant it. And then that's the end of the game unless they give him the relief he wants of going back to the D.C. Circuit en banc. That is, if they say no stay, then the mandate goes right back to Judge Chutkin and we're in business and the whole long detour involving immunity is finished. But they could take the case, and if they do, they probably, not certain, but probably would grant the stay, and they either could grant the stay subject to his having a petition for cert, or in some instances, they could treat the motion for a stay as a petition for cert. In either event, if they're going to take the case, they will put it, I think, on a very fast track where he'll have, a week, 10 days to file something on the merits, about the same for Jack Smith to respond, maybe a couple days to reply. And we're looking at their, if you zero in on what they've got going in March, it's a little tricky, but they can figure it out or have it's on its own day. In any event, they will be hearing the case soon, but then we'll be in the time frame where they're hearing the case. They have to decide the case. They maybe have to allow time for a dissent. And I just think in general, even if it doesn't go till the end of June, and I don't think it would, we're a few months away, and that's just 2 more months of manna for Donald Trump because it delays things. Now, of course, at the end of that time, it would be all definitive. But these are issues we've talked about, including, by the way, in this week's Talking Feds podcast. Will the court want more to think we have to decide this because it's important and we're the Supreme Court? Or will they say something like, A, who needs it after we're already tangled up in the Colorado case, and B, the D.C. Circuit really got it right here in a bipartisan way, and they did. So that's the really the important dramatic question that's coming up. Does the court just deny the motion for a stay, and then it doesn't much matter in the same way if they take the case or not. I think if and when they take it, they will rule against Trump, but it's now the sort of delay game. So will they deny the stay and leave it to the D.C. Circuit opinion in place, or will they say, no, we have to decide this? And I'd say the practical difference is a few months, and that probably translates into trial in a reasonable time frame where we're not in the heat of the election versus one in which we are. And that's going to, kind of present its own sort of difficulties or funkiness if U.S. versus Trump is going on while we're in the heat of a campaign. Along those lines, by the way, the last argument in Trump's brief is on behalf of we, the people, that this is the decision of the D.C. Circuit not granting him immunity actually harms Democratic interest, the people's interest in voting for the candidate of their choice, because it's all planned to just get him out, and it's all orchestrated by the Biden campaign, et cetera, arguments that will have zero purchase with the Supreme Court, but they supply and fuel a political talking point. So no real surprise, though interesting that he asked for even more time, kind of cheeky, to go to the D.C. Circuit as well. And we'll watch closely what happens in the next. We ought to know, I would say, by the end of next week, what the court's going to do with that. And it's really matters in terms of the timing of this, the most important trial of all. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.